160.58, conditional sealing of certain controlled substances, marijuana, or specified offense convictions. A defendant convicted of any offense in 220 of the Penal Law, 221, who completed a judicial diversion program under Article 216, or one of the programs heretofore known as drug treatment alternative to prison, or another judicially sanctioned drug treatment program of similar duration requirements and level of supervision, and has completed the sentence imposed for the offense or offenses, is eligible to have such offense or offenses sealed pursuant to the section. The court that sentenced the defendant to a judicially sanctioned drug treatment program may, sua sponte or on defendant's motion, order that everything be sealed. Oh, yeah, it says all official records and papers relating to the arrest, prosecution, and conviction which resulted in the defendant's participation in the program be conditionally sealed. In such case, the court may also conditionally seal the arrest, prosecution, and conviction records for no more than 3 of the defendant's prior eligible misdemeanors, which for purpose of the section shall be limited to misdemeanors defined in Article 220 or 221. They may only seal the records of defendants' arrests, prosecutions, and convictions when the sentencing court has requested and received from DCJS or FBI a fingerprint-based criminal history, including any sealed or suppressed information. The DCJS shall also include a criminal history report, if any, from the FBI regarding any criminal history information that occurred in other jurisdictions. The division is hereby authorized to receive such information from the FBI for this purpose. The parties, whoever the fuck they are, shall be permitted to examine these records. Semicolon. B. The defendant or court has identified the misdemeanor conviction or convictions for which relief may be granted. Semicolon. C. The court has received documentation that the sentences imposed on the eligible misdemeanor convictions have been completed, comma, or if no such documentation is reasonably available, comma, a sworn affidavit that the sentence imposed on the prior misdemeanors have been completed, semicolon, and D. The court has notified the DA in each jurisdiction in which the defendant has been convicted of an offense which, with respect to, okay, another horribly written paragraph. D. The court notified the DA of each jurisdiction where the defendant was convicted, where he wants to get the case sealed, and the court of record of such offenses and the court or courts of record for such they got to notify the DA and the court that the guy was convicted in, that they're considering sealing the records. Both of them shall get a reasonable opportunity, which shall not be less than 30 days, in which to comment and submit materials to aid the court in making such a determination. Like anybody's gonna fucking even give a fuck. 3. It's going straight in the garbage. At the request of the defendant or DA of a county where the defendant committed a crime that's the subject of a sealing application, the court may conduct a hearing to consider and review any relevant evidence offered by either party that would aid the court in its decision whether to seal the records of the defendant's arrests, prosecutions, and convictions. In making such a determination, the court shall consider any relevant factors, including but not limited to 1. Circumstances and seriousness of the offense which resulted in the convictions. 2. The character of defendant, including his completion of the judicially sanctioned treatment program. And 3. His criminal history. And 4. The impact of sealing on his rehabilitation and his successful and productive reentry and reintegration into society. And on public safety. 4. When a court orders sealing pursuant to this section, all official records including all duplicates and copies thereof on file with DCJS or any court, shall be sealed and not made available to any person or public or private agency, provided, however, that the division shall retain any fingerprints, palm prints, and photographs or digital images of the same. When the court orders sealing pursuant to this section, the clerk of such court shall immediately notify the commissioner of DCJS and any court that sentenced the defendant for an offense for which he's been conditionally sealed regarding the records that shall be sealed. 6. Records sealed pursuant to subdivision shall be made available to A. defendant or his designated agent, B. qualified agencies as defined in sub 9 of 835 executive law, federal and state law enforcement agencies when acting within the scope of their duties, or C. any state or local officer or agency with responsibility for the issue of gun licenses when the person made the application for such a license, or D. any prospective employer of a peace officer or police officer in relation to an application of employment. However, that every person who is an applicant for the position of police officer or peace officer shall be furnished with a copy of all records obtained under this paragraph and afforded to make an explanation thereto. 7. The court shall not seal the defendant's record pursuant to this section while any charged offense is pending. 8. If subsequent to the if the guy gets arrested and charged with a misdemeanor or felony, such records shall be immediately unsealed and shall remain unsealed, provided, however, that if such new misdemeanor or felony arrest results in termination in favor of the accused as defined in sub 3 of 16050, or by conviction for a non-criminal offense, the unsealed records shall be conditionally sealed pursuant to this section. So basically, if you plead down to a violation, they're going to reseal them conditionally. 160.59, sealing of certain convictions. These are definitions. A, eligible offense means any crime defined in the laws of the state other than a sex offense, an offense in 263, a felony offense in 125, a violent felony offense, a Class A felony offense,